welcome from the American Australian Association. We've got folks joining us tonight from Menlo Park, Miami, Minneapolis, Maitland, and Melbourne. I'm based in Cambridge, Massachusetts, and we've also got folks joining us from Worcester and Amherst, which are sort of in my neighborhood. I'd like to give a really warm welcome to Zjantelle Cammisa Markel. It's great that you're joining us again. It's been quite recent that we had an update, but there's more news for you to share, and I'm looking forward to hearing all of your news. Let's get started.
Hi, Louisa. Thanks for having me back again. We didn't expect that we'd be talking so soon, but there were so many updates that happened right after our last update that we thought it would be good to do this sooner rather than later. Just to go over, we're going to concentrate on specifics tonight. Some things that we've covered in the past include long-dated R94s, and if you can file an LCA and stay on that. We've talked about claiming unemployment insurance when you're on an E3 and other visa categories. We've talked about RFEs for an E3 and the difference between filing an I-129 in the US and consular processing at a consulate abroad. The reason I bring that up is that we're going to touch on that tonight when we talk about how premium processing has come out for the E3s. So if you want a more in-depth analysis of the difference between filing an I-129 and going to the consulate, you can always go back to that July webinar we did. In February, we did updates on the Biden administration and immigration. We also, in that webinar, talked about consulates people can go to renew their E3s. We're not going to talk too much about which consulates tonight with the E3s. We're more going to concentrate on the more recent updates, which is that premium processing is now available for the E3 category as of February 24th, which is a big update. I'm going to touch on H1Bs because the filing period for that is right now. So I want people to be aware of that because the window ends shortly. We've got Presidential Proclamation 10014 that was rescinded also on February 24th. And that was in relation to the people that were trying to get a green card from outside the US. Louisa, we spoke in depth about that last time because it significantly impacted anyone that had won the Divi 2020 lottery, and they were almost not going to be able to make that green card a reality. And now with the rescission of this proclamation, that is now once again a reality for those people, which is awesome. Green card holders. So we had probably more than 50% of the questions that we received for tonight's webinar were from a lot of green card holders that have gone back to Australia and coming up onto their being out up to 1 year or maybe even more than 1 year. And they're all really concerned and really stressed about what they should do, worried that they might be losing their green cards. So we want, first of all, those people should not be concerned. And we're going to spend a really good chunk of time on that tonight. Because it's been a recurring question for each of the webinars, and while we've touched on it each of the other times, I feel like we always address it right at the end and don't give it a full attention. So tonight we're giving that really full attention, and then we're going to talk about the update. There was an update about the Naturalization Civics Test, and we did get some questions that some people were confused on what that meant. So we're going to be clarifying that. And again, yes, we're going to talk about the E3 premium processing, what that means, and how people should look at it. Should they be filing premium processing? Should they switch from going to the consulate abroad to filing in the US? Because now that premium processing is available. So we'll guide people through that thought process of making that decision. So first update is right now is the registration period for H1Bs. I'm not going to talk too much tonight about H1Bs, but I did want to just touch on it because the registration period is right now. It started on March 9th and it ends on March 25th at noon. So if the people that think that they might need an H1B should be filing for this registration right now. And the other people that need to be thinking about it are employers that might need to file get an H1B for one of their employees. It might be a new employee that's not Australian and therefore doesn't qualify for an E3. The equivalent of the E3 for anyone who's not Australian is an H1B. Employers should look to people that are are part of their staff that are in OPT status, because typically after OPT, you will need an H1B if you're not Australian. If you have any employees in J1 status, often those employees need to transition to an H1B. And also, if you have any employees that are in E3 status, but might be wishing to pursue a green card. So firstly, we did have a lot of questions around this. I want to clarify that you can definitely go from an E3 to a green card, and that you don't need to change to an H1B in between. Where an H1B might be beneficial to have between an E3 and a green card is if the employee or the person needs to travel internationally frequently. And the reason is, when you go from an E3 to a green card and you adjust status in the United States, there's going to be a period of about 6 to 8 months while you're waiting for your travel document that you won't be able to travel internationally. If you're in H1B status, that doesn't apply to you, because when you file for adjustment of status, it's one of the categories, H and L status are the only two categories that you don't have to wait for that travel document, and you can continuously travel internationally even after you file your adjustment of status. So if you are a frequent international traveler in that instance, and you're on an E3, in that instance, it might be beneficial to get an H1B before pursuing the green card. But again, you don't have to. So if you think, oh, that's me, and you enter into the H1B lottery and you don't get selected, it's okay. You can still transition and get a green card from the E3 category. I put L1B here just because if employers have any L1Bs, they might like to consider the H1B as a strategy to gain an extra year of that employee's time to be able to work for that employer. Also, just coming back to OPT, some employers will have OPT employees where their OPT is still valid through till next year, or maybe even the year after if they're on STEM OPT. I still encourage those employers to file a registration now, because if they don't get selected this time, then they'll get, so they've got two bites at the apple, so to speak. Also, because while the registration period is now, even if you get selected, this H1B is not going to commence until October 1 of this year. So the way it works is there's this registration period right now. More than the 86,000 H1Bs that are available of people will register. Last year it was over 200,000. So at the end of that period, of between March 25th and March 31st, they will do the random selection and then notify the employers as of March 31st whether their employee was selected in the lottery or not. And then after that, the employer will have a 90-day window to actually file the full H1B petition. So just wanted to go through that and update people that they need to file now if they are looking for an H1B.
Zjantelle, in the past, in previous years, H1Bs would get a lot of press because the day the applications opened, they would just immediately get snapped up and they were totally oversubscribed. So given that you've got the date here of March 9th, does that mean that people are already shut out of this process?
So that's a great question. So before last year, the process was that April 1st was the first day you could submit an H1B application. And it's still the first day that you can submit the full application. But what happened historically in the past is that on April 1st, employers would prepare all of their H1B petitions, a full petition, and file it with USCIS on that very day. So trucks would arrive at USCIS, FedEx trucks with over 200,000 petitions. And then on the first day, the quota would be met and they would do the random selection of those H1Bs from that day. And so employers were spending a lot of money on preparing a full H1B petition that then got filed, and a lot of their employees may not have gotten selected. The rate of selection was less than 50%. So now with this registration period, they've given this full period of March 9th to March 25th, and then all of the submissions that come in during that period, that's the pool they'll select from. And an employer doesn't have to submit a full petition. They're just registering that employee. So they'll be notified if that employee was selected. And then once that employee is selected, it's after that the employer can then spend the more money on the attorney to prepare a full petition to file with USCIS. So if you haven't submitted it yet, it's not like you're going to miss out because the quota's been met from the beginning. It's they're taking the selection from that whole period. That's a great question, Louisa.
Okay, great. Thanks. That's good to know.
Okay, the next thing I wanted to talk about, which was on February 24th, President Biden rescinded that Presidential Proclamation 10014. That was the one you might remember that was preventing certain immigrants from getting their green cards issued abroad and then being able to enter the US as well. Certain green card holders that had gone out to get that green card were being prevented from coming into the US. And the predominant classes that were affected by that, it was not spouses of US citizens, but it was spouses of green card holders and children of green card holders. It was parents, siblings, and married children of US citizens, and anyone that was trying to seek a green card from outside the US, so consular processing of their green card from outside the US, under an employment-based category. They suspended all the immigrant interviews for those. And then the Divi 2020 lottery winners. And I'll come back to the Divi lottery winners in a moment, but what they're going to do, so now with the rescission of this, anyone that's a spouse of a green card holder or in these other categories that were waiting for their green card interview, and that was suspended for basically almost a year, will now start to see scheduling of their green card interview. And some people during that period that were scheduled for an interview, so in April, May, people had already been scheduled for their green card interview abroad. They would show up to their green card interview and it would get denied because of this proclamation. So anyone in that instance, the government has said we will reassess those and re-interview those people and give them another opportunity to have their green card approved to now be able to enter the US. Around this, I wanted to talk about now, because that was suspended for almost a year, April to February, the backlog that this has created. So as of January 2020, there was 75,000 immigrant visa cases pending with the national visa centers. So I'll explain what that means. When you submit a green card case that you're going to process and do your green card interview at a consulate outside the US, you submit the petition, and then USCIS will, when it's almost ready, will forward it to the National Visa Center that then corresponds with the consulate outside the US, Sydney, if you're Australian, and then the consulate will schedule your interview, and you go to your interview and you get the green card. So back in January of 2020, there was 75,000 immigrant visas, and this is global, not just particular to Australia. But in February of 2021, there's 473,000 immigrant visa cases pending, waiting for interviews. So we were talking about this in my office, and I don't know, I think that there are more immigrant visa interviews pending in other countries than particularly in Australia, but it does show that there will be a backlog for anyone that's waiting for a green card interview at the consulate abroad. So the reason I want to bring that up is that maybe people might think about a different strategy. If you have the opportunity to enter the US and convert your case to an adjustment of status case where you do your interview from within the US, you might be in better stead. It might go faster from within the US. I was talking to a client today who they have an EB5 green card approved, the petition is approved, and they're waiting for that to get to MBC to then get scheduled at the consulate in Sydney. They are Australian. And I was saying to them, look, it could take a significant amount of time because of these backlogs. So since you're here on another visa right now, it might be in your best interest to convert it to an adjustment of status case. In their particular circumstance, they need to travel internationally frequently. So they've decided they're just going to wait it out. But if you aren't one that needs to travel frequently and you're here, you might decide to convert it. to that. The other thing I wanted to bring up actually is that now that the government has said, let's prioritize, has said to the consulates, let's please prioritize these green card interviews, I think that's going to affect the non-immigrant visa interviews, because the consulates still have COVID restrictions and numbers, you know, they have restrictions on the numbers of interviews that they can conduct in a day because of COVID. So what we've seen as a trickle-on effect is this has affected non-immigrant visa interviews. So, and that then will affect even our E3 clients that are trying to get non-immigrant, you know, their E3 visa interviews at consulates abroad. So for example, we saw Mexico was approving emergency appointments quite frequently up until just recently, whereby now the frequency in which they're approving emergency appointments has significantly declined. And I think that is because what you see with these consulates abroad now is that they're saying, well, actually, we need to give priority to this huge backlog of green card interviews that we have to do for our own nationals. Then we've got non-immigrant visa interviews for our own nationals. And so third country nationals get the last priority to be able to get a visa interview at these consulates that aren't Australia, or, you know, where Australians are a third country national. So if you're trying to get an E3 interview right now and it's become harder at these consulates abroad, even harder than what it already was, this could be affecting that as well. So I thought that was interesting. Okay, so how does this affect the Divi lottery winners? So the great news is that they can now come in and finish getting their green card. So if you are a 2020 Divi lottery winner, we were in February, we were talking about if this wasn't rescinded, or if there wasn't a court case to help the 2020 Divi lottery winners and they hadn't been able to come in by March 30th, they would be not able to get that green card that they'd won. So now, if they have their Divi lottery sticker, the green card sticker in their passport, they should enter immediately if it's still valid, but they can also enter if it's expired, as long as it was a sticker, a green card sticker that was issued to them as a result of the court case that allowed immigrant visas to be issued to those Divi lottery winners between September 4th and September 30th of 2020. So those people will know who they are. So if your Divi lottery sticker is in your passport, it's expired, but it was one of those ones issued between September 4th and September 30th, you can come in on your expired immigrant visa and continue to get that green card, which is huge. The court did say that they don't know how long they'll allow people to do that, or how long these expired visas, they can come in on these expired visas. So given that, we want to encourage anyone that's in that situation to enter as soon as possible on their Divi lottery visa, because then they can get that green card. Otherwise, if they don't, then they will miss out and not be able to claim that green card. Some people have asked, well, I never got the immigrant visa issued before September 30th. Does this mean that they'll give me an interview now for that green card lottery win and give me a green card sticker? No. So if you didn't get the sticker in your passport before September 30th, then you're still a bit SOL. They did say that anyone that they're going to grant a national interest exemption as well to the Divi lottery winners that might be currently in one of the countries that can't enter the US right now directly to the US. So those are, if you're in Europe, China, Iran, UK, Ireland, Brazil, or South Africa. So if you're in any of those countries, and this travel restriction still sticks for anyone even traveling outside of the US right now, if you're going to Europe, or you're going to the UK or Ireland or Brazil or South Africa, you cannot enter back to the US directly right now. You either have to get a national interest exemption, or you have to pass through another country that's not part of this restriction for 14 days before entering the US. So just a reminder that that restriction is still in place. The restriction is lifted. They're saying for Divi lottery winners, we're automatically granting a national interest exemption. So those people will be able to travel directly to the US from those countries. So Divi lottery winners are winning again. So that's good.
I don't know, Zjantelle. I mean, for any Aussie who's flown to the US, it is a long flight. You're tired when you get to the end. You arrive at the airport, you hand your documents over. How can you feel assured that the person you are giving your documents to is across all of this?
Yeah, absolutely. So part of the announcement, there was USCIS did announce and did give the instructions on this. And so it does say that the Divi lottery winners can enter on their expired visa. It says that they are automatically granted the national interest exemption. So I encourage my clients to print that out, take it with them to the airport, show it to the airline crew, so that they can get on the plane and obviously, you know, when they arrive as well. Typically, you won't be able to get on a plane unless they know you're going to be able to be admitted on the other end. So if the airline crew is at all unsure as to whether they're able to board you because of this proclamation, their typical procedure of what they do is they contact Customs and Border Patrol, CBP, either in the US or there are limited local CBP officers in most countries. So they will, so in Australia, they will contact the local CBP officer and say, okay, this is this person's situation. Can you confirm for us this person will be able to enter the US so that we can board them on the flight? And once they get that confirmation, the person will be able to board on the flight. So if ever you've been held up at the airport before with the people that are checking you in, we have to check whether, that's typically what they're doing.
Okay. All right. So on the topic of green cards, about 50% of the questions we got for tonight are from those who are outside of the US and are worried about their green cards. So can you talk about this?
Yeah, absolutely. So I thought a good way to approach this topic would be in relation to the way people would, the categories that people would fall into with respect to how long they've been outside the US and then what they should do. And I'm going to just tell people what they should do. So if you're a green card holder who's outside of the US for less than 180 days, then you might want to consider returning to the US before you hit that 180-day mark so that you could preserve your ability to file for US citizenship. So if you're concerned about US citizenship and it's been less than 180 days, try and come back. If you're not that concerned with US citizenship, or you don't want to come back, then that's okay, because you don't have to come back before 180 days. So then you fall into the next category, which is you're a green card holder who's been outside of the US for more than 6 months, but less than 365 days. Okay, so what should those people do? If you can return to the US before the 365-day mark, then that's great. And the reason it's great is because you won't get any pushback when you come, well, you shouldn't get any pushback when you come through the airport and the CBP officer, says, how long have you been outside the US? 364 days. Okay, great. Here you go. Welcome back. So you should hopefully not get put into what's called secondary inspection for more questioning. Also, under certain circumstances, you may still be able to qualify to file for citizenship, even though you've gone past the 180 days, if there's certain other measures in place, and we'll come to that. I'm going to talk a little bit about citizenship, so we'll come to that. But what about, this is the main group, and the group that has been most stressed, is the people that have been outside the US for more than 300, well, they're coming close to their 365 days, or it's been more than 365 days. I've had so many calls from clients that are coming, they're at their 340th day, and they're like, do I have to be getting on a flight in the next 20 days? Like, what am I going to do? I'm going to lose my green card. They're going to take my green card away from me when I come. Do I have to get on a flight straight away? Or people that have realized it's been 365 days and they're freaking out saying, oh my God, it's been 365 days. And now they start Googling and they are reading horror stories that the green card's going to get taken away from them and that they have to apply for this returning resident visa, and they're not going to be able to come back when they want to. And so I just want to say I'm going to demystify this and that all those people have to not worry, because they can definitely come back. And I'm going to tell them how and what you should do and not do right now. So the first thing is, doesn't matter how long you've been out of the US on your green card, even if it's more than 100, even if it's been a year and a half at this point, what you're going to do is you are going to just come back. So if your green card is still valid, you're going to use that. You're going to shop at the airport. They're going to let you on the flight. Some countries, when you check in, if you have been out of the US for more than a year, might give you a hard time with getting on the plane. Typically, this doesn't happen in Australia. It's more, it happens more in India and some other countries, but I've not heard that happen in Australia. I've had a lot of clients that have come even after 2 years and not had a problem with getting on the flight. So if your green card is expired, most of the people that have been contacting us, their green cards are still valid. They've got the 10-year green card. But if your green card is expired, you had the 10-year green card and you were 9.5 years and you left, last March, and now, oh my God, now I'm looking at my green card's expired. You can file an I-90, which is the renewal of your green card from outside the US. You're not going to get the green card in time, the renewed green card in time. But what USCIS has said is that the receipt notice of that I-90 filing can be used together with your expired green card to get back into the US. So if you're in that situation, you're going to file an I-90, get your receipt notice, and you're going to go to the airport, get on the plane, and you're going to come to the US. Okay, so first of all, if you've been out of the US more than 365 days, then you are going to need to get the exemption to leave Australia if you're in Australia. Because Australia has this requirement, if you're an Australian citizen, that if you've spent more time inside Australia than outside of Australia in the last 24 months, then you need to apply for an exemption to leave. So with the math, even though math's not my strongest, but if you've been in Australia more than 365 days, it means you've been in Australia more in the last 24 months than less in the last 24 months. So you're going to apply for the exemption. What I want people to do when they apply for that exemption is that you are going to state that you are leaving Australia and you're coming to the US for more than 90 days, and that you plan to you're coming back to the US to live in the US. What people also need to know is that if it gets denied the first time when you apply for that exemption, if that gets denied, you can apply again. You can apply as many times as you need to get it approved. And if you have tried 3 times and you're just not getting there, contact an immigration lawyer that can help you and get it approved. We've gotten it approved for clients that have tried on their own before and not been able to get it approved. So you'll get the exemption to leave for sure. Now, you've got your exemption to leave, go to the airport, and you're going to now arrive in the US with your green card, and you're like shaking in your boots because you're like, oh my God, I'm going to get grilled. So what I say to clients is, come armed with documentation to show that you did not intend to abandon your green card, because that's what the immigration officer is going to be saying. Look, there's a presumption that because you were outside of the US for more than a year, that you're abandoning your green card. So you want to be able to say, look, I'm not. I had zero intention of abandoning my green card, and here's evidence that I have with me to show you that. So you're going to bring evidence that you've continued to file your tax returns in the US while you were gone. You're going to show if you own property in the US, you're going to show that you own property, or if you maintained a lease on an apartment, you're going to show that. Bills, utility bills that you continue to pay, if you continue to pay a phone bill in the US, any of those things, you continue to maintain a bank account. If you continue to use your US credit cards while you were in Australia during that time, you want to show that. If you had any family members you left behind in the US, you want to show evidence of that. If you continued, some people went back, but they kept working for their US employer while they were back there, just because, in Australia right now, there's like no COVID. So of course people wanted to stay there a long time, but they might have still be just working remote for their US employer. That's great evidence that you were not intending to abandon your green card. You may have had flights booked to come back sooner that got cancelled. So evidence that you tried to get back, and I had flights booked, I was first intending to come back on this date, and then COVID hit, and then I couldn't get flights, and then flights were super expensive, and then I couldn't get out of Australia, and then I wanted to get a vaccine, and then I wasn't feeling great. You want all the evidence of all the excuses, or evidence that you did try to leave but couldn't. Have a one-way ticket to the US. So don't come to the, to the officer with your ticket that arrived with a ticket that goes back to Australia in 3 months. A few people ask me, what about a doctor's letter? Is that going to help to say that I was immunocompromised and I couldn't get on the flight? It could help. I don't think it's going to make or break your entry to the US. In fact, you're definitely going to be entered into the US regardless, even if you don't have any of these documents. But just having these documents with you will make it easier for the immigration officer to not argue with you about your prolonged absence to the US. So now what if this immigration officer says, well, listen, I don't know, I think you really did abandon, you were out for too long, you've abandoned, here's a form I-407, record of your abandonment of your green card, sign this, we'll let you in on ESTA, and then you'll be a tourist, and then you just go back and you'll get a visa, but give up your green card because really you don't live here anymore. So what I'm going to say is, if you want to keep your green card, absolutely 100%, unless you actually want to get rid of your green card, and some people do for tax purposes, then this is your opportunity to get rid of your green card, and you sign that and you've given up your green card. But if you want to keep your green card, under no circumstance will you sign an I-407. And I have seen too many times where an immigration officer's literally convinced someone, oh no, it's no problem, just sign this, because really you just don't live here anymore. And they've signed it not understanding the consequences of it. So if you sign this I-407, you are knowingly, willingly, and affirmatively waiving your right to an immigration judge, and you're giving up that green card. There's no appeal to it. That's it. You've signed it. You're done. Green card's gone. Garbage. Can never use it again. Start from the beginning if you want a green card again. So don't ever sign form I-407. Right. So now this if the immigration officer is giving you a hard time, they're trying to get you to sign this form, it means that they're really giving you a hard time. So what you're going to say is, I'm not going to sign that. And in fact, I'd like to request a hearing before an immigration judge, so that the officer at the airport cannot take your green card away from you and has to let you into the United States. So you will be let in to the United States, and you'll be given a notice to appear for your hearing in front of an immigration judge with respect to your permanent residency and your ability to keep that green card. It takes years to get that in, for this process. And during those years, you maintain the ability to keep working, keep traveling internationally as if you've got the green card. And by the time you end up in front of the immigration judge, hopefully you will have spent more time in the US than outside of the US, so that you can show the immigration judge, as you see, I never intended to abandon it. I've been living here all this time. Here's my job. Here's my dog. Here's my babies I had here. Here's my new house I bought with the beautiful picket fence, wherever it is, you know. But so now also, if the immigration judge says, no, I really think you did abandon it, you have an ability to appeal that decision. So as you can see, this process, you know, you're going to keep your green card. So don't worry. If you've been out of the US 365 days, you will be let in to the US. You will be let in. Just don't let them take your green card away from you at the airport. Say, when you arrive, say that you want to be seen in front of an immigration judge. If you're having a really hard time, never file an I-407. Also, in this situation, if you do get seen before an immigration judge, it's up to the government to prove that you, by clear and unequivocal and convincing evidence, that you did intend to abandon your green card. So if you're coming with all this evidence that you didn't intend to abandon your green card, it's going to be very hard for them to prove that. So, and just from experience, I've been an immigration attorney for over 21 years in the US now, and all of my clients that have come in after the 365-day mark, and even up until 2 years out, or sometimes even more, I've spoken to them and told them to do this, they've all been let in, and none of them have had to go in front of an immigration judge yet. So I think you'll probably just be let in. I think it's minimal chance that you're going to get in front of an immigration judge, but even if you do, chances are you'll win. It'll just be an annoying process. So I had a very good friend. So the other thing is that people in this situation have been Googling And so, you know, it's like when you Google, you think the world is coming to an end and, oh, I've got to do this. No, I've got to do that. And if you do Google, I'm a permanent resident and I've been outside of the United States for more than a year, what do? It tells you to apply for a returning resident visa. So a really good friend of mine who left last February, he planned to come back originally with his family, I think in April, but then just COVID hit and there they are. They stayed in Australia, children that went to school and so forth. He called me about a week ago in a panic. Oh my God, what am I going to do? We're not coming back till April. We left last February. It's been more than a year. I'm screwed. They're going to take my green card away from me. I have to apply for this immigrant visa. This is really complicated. And I'm seeing this immigrant visa is going to take me forever. We need to get back by April. We're not going to be able to get back by April. What am I going to do? I'm like, step back from the ledge. It's going to be okay. You're not going to apply for this immigrant visa. So I just want people to know they're not applying. You're not applying for an SB1 returning resident visa. And these are the reasons why. It is an option. You can go down that path, but I do not recommend that path because, number one, you have to get an appointment for this returning resident visa. It's taking more than 4 months to even get an appointment. When you get an appointment, the immigration officer is not authorized to make a decision on their own. They have to get a supervising officer to also approve one of these returning resident visas. The rate of, it's a 30% rate of denial of these. It's up to you to convince. So in the other situation with the judge, it's up to the government to prove that you intended to abandon your green card. Here, the burden's on you to prove you didn't intend to abandon the green card. Now, you're in Australia, you've been in Australia for a year. It's harder to prove it from within Australia and you've been there for such a long time. If they deny it, and you could just get an immigration officer that's in not such a great mood that day and be like, no, I'm denying this. There is no appeal process. So you're done, right? Now you've been denied, your green card's been taken away from you. And so you can't come in on ESTA because you're not going to qualify for ESTA. So this means you need to apply for a non-immigrant visa to get into the US. And chances are they're not going to approve a non-immigrant visa because to get a non-immigrant tourist visa to enter the US, you need to show non-immigrant intent, and you've just been there showing that you've got immigrant intent, that you want to keep your green card. So now your only recourse is to start the green card process all over again from within Australia, and you're not going to be able to come back into the US until that's approved if you still qualify to apply for a green card all over again for like another year and a half or so forth. So it can be quite disastrous to go down this process. So if you want to keep your green card, do not get an SB1, returning resident visa, just come back to the US. I want to give an example. I was on a panel of immigration attorneys 2 weeks ago, and this was the topic that people were talking about. And there were attorneys that have represent predominant nationalities. So, you know, I represent a lot of Australians, and then there was another attorney on there that represents a lot of Indian nationals. And she gave a story about a client that had tried to apply for an SB1 immigrant visa at the consulate. The person had gone back home because her mother had cancer. So she was there until the mother passed away. And then during that time, the person herself got diagnosed with cancer, underwent chemotherapy, and had been now out of the US for a year and a half on their green card. Tried to apply for an SB1 and it got denied. So even in such, I can't think of more compelling, you know, reasons than that to be outside the US. So this is just an example of, you know, you just don't want to go down this road and risk it. So come back to the US on your green card, you're going to get let in and you're going to get to keep your green card. Okay, so I know that was a lot to talk about just to convince people to just come in. A quick reminder for anyone returning to the US, you do need to get the COVID test and show a negative test that was taken within 3 days of departing and coming to the US. Or the alternative is showing that you've been COVID positive and have now recovered from COVID. This is also, now that people are starting to get vaccinated, just want to remind people that this is still the negative COVID test or evidence of positive COVID test plus plus evidence of recovery is still required even if you've been vaccinated. So just wanted to highlight that too. Okay, so I spoke about, you know, when you're outside of the US and how, you know, keeping your green card. So for the people that want to preserve their ability to file for citizenship, I thought I'll touch on this because for them it's really important to come back before the 180-day mark. And the reason for that is that there's a physical presence requirement to qualify for citizenship and a continuous residence requirement to qualify for citizenship. So what the physical presence requirement is that, so people will qualify for citizenship in two ways. If you got your green card through marriage to a US citizen, you will qualify after 3 years of having a green card. And at that point, you have to have spent at least 1.5 years physically in the US out of those last 3 years. For anyone that got their green card any other way, other than through marriage to a US citizen, then the time period you have to have had your green card is 5 years, and you have to have been in the US 2.5 years of physical presence. There is then a continuous residence requirement, and the continuous residence requirement is that you have not had a trip outside the US that lasted more than 180 days at one time. If it's between 180 days and 365 days, there is still a possibility you might still qualify to apply for citizenship if you didn't terminate your employment with a US employer, if your immediate families remained in the US, and if you retained full access to a home in the US. So given that those, you know, sometimes people don't qualify for all those, I really usually encourage people to please, you know, they definitely should come back before the 180-day mark if they want to become a citizen sooner rather than later. If you didn't and you were out of the US, you know, more than 300, once you hit 365 days, your time clock of the 5 years or 3 years starts again. So it's not a big deal. It just means it's going to take longer to become a citizen if you've been out of the US on your green card for more than 365 days, if citizenship is important to you. So if you've been out of the US more than 365 days, you want to become a citizen, you're going to have to wait another 4.5 years before you can file for citizenship if you got your green card any other way than through marriage to a US citizen. And you're going to have to wait 2.5 years if you got your green card through marriage to a US citizen. So this is it's something that people should just consider, that they're not going to be able to just enter the US and then say, oh, I'll file for my citizenship now if they've been out more than a year. There are some exceptions to that, but most people won't qualify. It's if you've been with a US government, you've been employed by a US government organization abroad, or you've been in a security related position abroad, or you're a religious worker or qualifying military service. So not many people qualify for that exception.
I just wanted to ask a question at this point of something that I'm kind of fascinated by and that I know has been in the news recently, and it's about the civics test. And I know that we got a lot of questions about this. While we're talking about preserving citizenship, there was an announcement about the civics test changing. So can you explain what the test is and what the differences are and who it's going to affect?
Yeah, so I'm going to try and breeze through this update really quickly because the group of people that it will affect is very narrow. And the reason is, so the 2008 civics test was in place up until December 1, 2020, at which time Trump said, we're going to put in a new civics test called the 2020 civics test. And what the civics test is, it's part of your citizenship test. So when you go for your citizenship test, they're going to ask you questions about your application. They do two other things. There's an English test. They test your ability to read, write, and speak English. And then they give you this civics test, which is your ability, they test your ability to know about the American government and the history of the United States. And you have to learn, there's a set of 100 questions and you need to get, they will ask you 10, you need to get 6 out of 10 right. So the 2020 test became 20 questions and having to get 12 right. And basically when Biden looked at that and said, you know what, this is really making it difficult for people to become citizens, people are failing this. So, and Biden came out with this executive order on restoring our legal immigration system to make it not as difficult for people. So he said, let's go back, we're going back to that that test that we've been using up until December 1st, 2020. And that will go into effect on March 1. He did say that anyone between March 1 and April 19th, if they filed after December 1 and their interviews before March 19th, that they've got the option of sitting either the 2020 test or the 2008 test. So the interesting thing on that is, because I'm so familiar with when you file for citizenship, it takes forever to get your citizenship interview. You know, I sat and looked at this and thought, who would this even affect, right? You filed after December 1, 2020, and you have to have your interview before April 19th. Like, is there anyone this could affect? So the only people it could affect is military spouses, Department of State spouses, or anyone that lives in a city whose field office is processing naturalization cases in 4 months or less. So then I was curious. I'm like, okay, New York's taking forever. Is there any field office that could be processing citizenship in 4 months or less? So I thought to myself, well, where could that be? Somewhere where there's not many immigrants. And then it's like, what about Cleveland? And funnily enough, Cleveland is processing green card cases. If you look here, it's right here, in 4 to 11.5 months. So it's possible, if you live in Cleveland, that this might apply to you. What that set me on then was, well, how long is it taking, you know, for most people to become a citizen? So I took what we did, Louisa, was you'd provided us last time with a list of people's questions and the city they live in, where the questions came from. So I thought what might be interesting for the audience is to take these, the most of our viewers are from, put them in a chart and show how long it's taking if you file for citizenship to then become a citizen. And I think what's interesting here is you'll see that, so in New York, it's quite a long time, 16 to 20 months. Then Boston, which is not that far away, is 7.5 to 15 months. So, or you've got, you know, exactly like Cleveland. So why is this interesting right now? Because right now it's interesting because people are working remote. People are going and living in, could go live in Cleveland or Boston for 9 months and become a citizen if they wanted to. So if you're desperately want to become a citizen pretty quickly, right now you could choose to go live in one of these cities. You do need to have been there 3 months to qualify for the field office, one of these field offices. You have to have had residency there for 3 months to then be able to file as a resident of that field office in that jurisdiction. So I just thought that was interesting for anyone that wants to hurry and become a citizen.
I don't know, Zjantelle. I mean, I know a lot of Aussies who've actually gone home in the last 12 months. So many people are leaving right now. Why would people apply for US citizenship at the moment?
Yeah, so, you know, such a good question. But this is how I look at it. If you become a citizen, you can then leave the US for as long as you want and never have this difficulty of any restriction with coming back. So you could go back for 6 months, you could go back for a year, you could go back for 5 years, and you'll always be able to come back to the US. So a lot of the green card holders that went back and are finding themselves in this difficult position, if they would have become citizens already, then before they left, then they wouldn't have had this issue of being stressed about coming back. So, and a lot of my clients that have US citizen kids, I always find that often they might think they're going back, and they do go back, but then when their kids grow up, they want to go to college in the US. And by then the parents have retired. They don't really want to come here. They've given up their green card at that point. And they, you know, to come back, they can't spend more than 90 days here till their child is over the age 21 to sponsor them for a green card again. So if they've become a citizen, they can always just come back. So yeah, there are definite reasons. I mean, but obviously, you know, tax-wise, sometimes people don't want to become a citizen for tax reasons. So I always encourage people to speak to a tax professional as well, you know, before they apply for naturalization, and predominantly if they have significant global assets. But otherwise, you know, there are definite benefits to becoming a citizen.
I know that we had a question tonight from Anthony via our chat. And it's about the other big news item that's come out since our last update, and that's about premium processing now being available for E3. So what does this mean, Zjantelle?
Okay, great. So premium processing, first of all, what is it? It's when you pay an extra $2,500 to USCIS to get a response on your petition within 15 calendar days. So if you're in E3 status, when does this apply to you? It only applies to you if you're filing for your E3, either a change of employer E3 or an extension of an E3 from within the US. Please note, you cannot file an I-129 to get an E3 from within the US if you're in visa waiver status. So in that instance, you can't. But if you're in any other status and you're trying to change to E3 status, you can now file premium processing. If you're trying to change employer, you can file premium processing. Or if you're extending your E3, you can file it with premium processing, which is the $2,500 for a response in 15 days. Okay, so who does this benefit the most? The category that is, will experience the most relief from having this premium processing in place is change of employer E3 petitions. So typically, if you're here on an E3 and you want to change employers, you cannot start working for that new employer unless you've gone and got a new visa abroad, or you've gotten a new visa approved through USCIS. Before premium processing, filing it within the US was taking about 8-9 months to get an approval, and you couldn't start working until it got approved. So then that wasn't really an option. So people were forced to have to leave the US, try and find a consulate, try and find a country that they could get to and come back. Like during COVID, with so many travel restrictions and consulate closures, even that's been difficult. So the change of employer E3s have been severely impacted by COVID for that reason. So having premium processing in place means that these people can now file a petition with the USCIS and feasibly start working for their new employer within 2 weeks without having to travel abroad, which is great. Same thing with change of status to E3. Same thing applies. Can't start working until that E3 petition is approved. People were having to travel abroad. Now they don't necessarily have to. Can file premium processing within the US, get it approved in 15 days and start working, which is great. Other cases that might benefit is, so you don't have to, it doesn't apply to only cases getting filed now. So if you filed your E3 petition a while back and it's still pending and you just need it to get approved already, you can upgrade your case to premium processing. So you can pay the $2,500 now and then get a response in 15 days. I wanted to point out, there have been a lot of questions around this. If I file my E3 premium processing and I have my spouse filing for either a change of status to E3D or an extension of their E3D together with an EAD, and in our last webinar, we talked about this group because they're severely impacted and delayed because the E3Ds, together with their EADs, require biometrics to get approved, and the biometrics are severely backlogged. So I want people to know that if you file premium processing for your E3 will get approved or adjudicated, a response in 15 days, but the E3D and EAD will not. So that will not get adjudicated in 15 days. So people need to be aware of that. While the E3 needs to get approved for the E3D and EAD to get approved, it might speed it up a little bit, but it's not going to make a significant difference because of the biometrics. They still need to get biometrics. Those are still delayed and they don't get processed, premium processing together with the primary. So just wanted to point that out. Okay, who gets least benefit? If you're extending with your same employer, if you file an I-129 in the US, you automatically get 240 days of extended work authorization anyway. So you don't necessarily need to pay the $2,500 to get an approval straight away with that. But if your case, we did have some cases that were extension with the same employer that were pending so long that they were getting close to the 240 days. So if you're in that situation, you might say, well, I'm close to the 240 days. I don't want to have a gap in my employment. I don't want to have to stop working. So let's upgrade this to premium processing so we can get an approval or a decision much faster. So is premium processing for everyone? There's certain factors people need to consider. One is that when you file the I-129 in the US, you're not going to get the visa put in your passport. So when you file an I-129, even if you're filing at premium processing, the next time you travel internationally, you will need to do the visa process again at a consulate abroad to get the visa sticker in your passport to be able to come back in the US. So really, you're doing the visa process. If you're going to travel in the next 2 years, you're going to be doing the visa process twice. So people should consider that. Is it cheaper for me to spend the $2,500 on trying to find a consulate abroad, going and get the visa and coming back, rather than spending the $2,500 on on hastening my petition with USCIS. Other things to consider, it might not be an approval that you get in 15 days. It could be a request for evidence, notice of intent to deny, a denial, investigation for misrepresentation or fraud. Typically, it's either an approval or a request for evidence. If you get a request for evidence, depending on the type of request for evidence, you will have 30 to 90 days to respond. And typically you need to use that amount of time to prepare a really strong response. Our previous webinar goes into what an RFE can request. And so people can look at that to get an understanding of what an RFE is like. But typically the RFE will be based around if the employer is not a strong employer, if the employer, wage level, and specialty occupation are the three main areas that will trigger an RFE, a request for evidence. So if the employer has not been established for very long, if they don't have very many full-time staff, if they did not make much money in the last financial year, or if you're an owner of the company, this could trigger a request for evidence. Wage level, if you're submitting your LCA and you're at wage level 1, those often trigger a request for evidence. So I like if I'm filing an I-129, I typically like the wage level to be at least wage level 2. And then the big RFE, the ones that typically need 90 days to respond to, are the ones around specialty occupation. So that's when your occupation that you're in is not one that requires a degree in just one specific field to be able to do it. So if multiple degrees could be used for your role, then this could trigger a specialty occupation request for evidence. So just reminder, if you get a request for evidence, you're not getting an approval now in 15 days. It could take up to 4 months. So now maybe leaving and getting your visa would have been faster. So I've kind of given, and I know we're coming up on time, so I won't spend too much time on this. This is sort of a flow chart of how I often look at, is premium processing right for a person? And it's really like, what type of case have they got? Are they a slam dunk occupation? And if they are, then typically filing premium processing is great, unless they're like, you know what, I'm going to be traveling frequently anyway. Let me just spend that $2,500 on getting the visa abroad. And if it's a change of employer or the I-129's already been filed, then I look at what's the likelihood of a request for evidence. And if the likelihood is high, then we might opt to looking at consulates. If the likelihood is low, then great. So this is just sort of a flow chart of how we look at it. And there we go. Oh my gosh, right on time. Look at that.
All right, let's hit these questions, Zjantelle. Are you ready? We got a bunch of questions. Okay, so let's go through these. Going back to green cards, what about those people who have conditional green cards and not 10-year green cards? Do those people have to get back to the US too?
Okay, so a conditional green card. The important thing there is that when you have a conditional green card, at the 2-year mark, you need to file to get the full 10-year green card. So when you're filing for that, you do not want to have been outside the US for more than 365 days, because you're trying to say that you really want to become a permanent resident. And so if you've been out of the US for more than that, you're not showing your true intention to become a permanent resident. Also, what I want to point out, Louisa, is that what is critical is that you have a 90-day window to file that, what's called an I-751, which is removing the conditions on that conditional green card. And that has to be filed in the 90-day window before that 2-year green card expires. We've had questions of, oh, well, has there been during COVID some exceptions to that I can file it later, or will they, you know? So no, like if you do not file it after that 2-year green card expire, before that 2-year green card expires, and in that 90-day window, you will lose the green card and you have to start all over again. So no concessions are made under that, unless you're actually, there are some exceptions, but not many. So I just wanted to point that out. If you've got a conditional green card, do not be lax on filing to remove the conditions on that on time.
Right, another green card question. What about those who come back to the US near the 365-day mark, but then want to return to Australia again for an extended period of time? What should these people do?
Excellent question. So what these people should do is what they should have done before they left, but they didn't know they were going to be in Australia forever. is there is an ability to preserve your green card if you're going to be out of the US for a prolonged period of time, and that's called an I-131 re-entry permit, and that allows you to be outside of the US for up to 2 years and not be deemed to have abandoned your green card. So they'll give you a re-entry permit. You can be out for as long as you want, up to 2 years, and come back and not have any trouble coming back in. So for any of my clients, I have got a few clients who've said that. They've said, oh, I'll come back in because I don't want to lose my green card. But then I know I really want to go back again for another 6 months. What should I do? So with all of them, and the 131 can only be filed from within the US. So you cannot file that from Australia. Have to be in the US at the time of filing. You will then get a biometrics appointment for that. After your biometrics appointment, you can leave, have the re-entry permit sent to someone in the US that can mail it to you, and then that's the document you'll use to come back to the US and not have pushback when you come back in if it's been a prolonged absence. So I highly recommend that.
Very handy to know. Regarding the 3-month window for people filing their green card, have there been any concessions for missing this period given COVID?
Yeah, so no, that's exactly what, no concessions for that. So do not miss the window.
Right. This question was asked by a bunch of people, Lisa, CX, and Tali, and it's regarding the process transitioning from an E3 to a green card. Tali's question was, how can you do this without marriage? CX and Lisa wanted to know, about the intent. So can you talk a little bit about this?
Yep. So so you just need to be cautious with timing when you go from an E3 to a green card. The green card process, employment-based green card process, has a number of steps involved. This is kind of a big, long answer, but I'll try and shorten the answer. So when you get an employment-based green card, typically it will be under a process called PERM. The first step of the PERM is the employer is required to test the labour market and file a labour certification with the government. And on that whole step does not include the person's name, and nothing is filed. It's not an immigrant petition filed for the person. That step there to get a labour cert filed and then certified takes about a year. So you can be here on your E3 during that period. Then, depending on where the visa bulletin is at, these are terms that if someone has a consult on this, I show them the visa bulletin, really explain it really clearly. The visa bulletin determines when someone can file step 2 and 3 of the green card when they're getting a green card through their employer. If their E3 still has some time on it, they can, and the visa bulletin says that they can file step 3 at the same time as step 2, then they can go straight onto filing their I-140 and adjustment of status, and they don't need their E3 anymore. So now they're on this adjustment of status period, and when they file that, they're filing for a work authorization document and a travel document. And they cannot travel internationally till they get that work authorization and travel document. So they just they're just not going to be able to travel during that period. The other thing, reason why you have to be really cautious with timing is that you want to have at least 6 months left on that E3 at the time you file for that, so that you'll continue to be able to work for your employer up until the work authorization document comes through. So if you time it perfectly, you can seamlessly go from an E3 through to your green card. You might get to the point where you're ready to file step 2 and 3, but you don't have 6 months left there to wait. So typically then I'll say to my clients, okay, we're going to get you to renew your E3 one more time before we file the I-140. So you haven't displayed immigrant intent yet. And now you're going to have another 2 years to complete the green card process. And typically that's ample time. So you just have to be on the dates and the timing, and you can, we've done it hundreds of times. So definitely doable. If you're going to, there's nuances though. You need to know what you're doing, right? So if you're going to have to renew your E3 to continue working with that employer, you can't then file step 2 and 3 until 90 days after having got that E3, because otherwise it does display that when you went and got that E3, you may have had immigrant intent. So it's doable. It's just a matter of being on the dates and timing it out properly. and knowing that you have a period that you won't be able to travel internationally, but if you time it out right, you should be able to work consistently all the way through.
All right, we've got a few more questions. Two of these questions are on the E3D, but the first question is a quick one. Is the LCA processing time still 7 days? And that is from Lucinda.
Yes, LCA is 7 days. That's standard. It's been like that for a long time. Back in the day, there was a period when you would file an LCA and get it back instantaneously, but it hasn't been like that in like over 10 years now. So LCA is 7 days.
Okay.
And you have to Louisa, if the employer's never filed an LCA before, they have to do one step before that, which is getting the EIN verified in the Department of Labor's system to be able to file the LCA, and that can take a couple of days. So, you know, the whole process of getting an LCA certified could take a bit longer than 7 days if the employer has never filed an LCA before.
Okay, great. Thank you. From Shreyas, my wife is renewing E3D for the third time, an EAD. Does that need biometrics?
It does. So when you're renewing the E3D, so for those people, it might be faster to get the E3D outside the US, come back in, and then file the EAD, because that doesn't need biometrics. It's because if you're extending the E3D in the US, the biometrics is attached to the I-539, which is used for extension of the E3. So if you got the E3D outside the US, came in and filed the EAD, it would go faster in 4 months rather than about 9 months if you do it all from within the country. Louisa, last webinar in February, we mentioned that the EADs and 539s, so that extension of E3D or change of status to E3D, and the EADs are up for being eligible for premium processing with an extra $1,500 and $1,750 respectively. They haven't implemented it yet, but hopefully, since we've seen February when we did the update, premium processing wasn't available for the E3s yet, and we'd said it's coming, and then bam, it came. So I'm hoping that it's going to be bam, it's here for those E3Ds and EADs, because that's going to be the major game changer for so many Australians, because we've had so many spouses that have, you know, had to lose, that have lost jobs, or had to get on their own E3s. So that's where premium processing could be useful. So for that person that said that, if they're waiting for their EAD, if your spouse qualifies for an E3, you might decide to change strategy and apply. If you can't get out to a consulate abroad to get their E3, then you could file premium processing of an E3 petition in the US for your spouse, and then your spouse can be working in 2 weeks rather than waiting for that EAD that's going to take potentially 9 months from filing, together with that extension of the E3D. So it's a good time to, if you're a spouse, if you're an E3D spouse, it's a good time to consider other options, especially if you are an Australian spouse yourself, because then you potentially could qualify for your own E3. If you're not Australian nationality, then that premium processing will become critical for people in that category.
And so this last question, if you file an I-129 without premium processing, is the E3D still done separately? And can you file for an EAD at the same time?
Yes. So you can always, whenever you file an I-129, you file the E3, you can file the E3D and EAD either together with it or separately, and then mention the receipt notice number of that original 539 filing. Or you can file all premium processing, but just know that filing a premium processing isn't going to speed up that one.
Zjantelle, it's been a pleasure. It's always so much fun to chat with you. I find the updates really interesting. And for an Australian, you know, all of this is interesting, because no matter where you are in the process, like what's coming up ahead is really important to know. So thank you so much. I look forward to our next update.
But hopefully, I really wanted to ease those people that, because like so many of those questions were for those green card holders outside the US, and I know I've had clients call me multiple times, are you sure? Are you sure? Are you sure? So I just want them to know, I'm sure. I'm saying it to so many people right now, I wouldn't say it live on a webinar if I wasn't sure that they will be able to get into the US.
Oh, and on that note, we will have a recording of this available within 24 hours. So if you missed anything, or if you want to hear something again, please visit our website. And thank you again, Zjantelle. I look forward to seeing you again soon.
Thanks, Louisa. See you soon.
Bye.